right, we're ready to begin our afternoon. Here we are in 3B District Court. We have 4 separate defendants set for this afternoon. Yes, 3. The matter of People versus Christopher James Giddens, file 252590, is charged with breaking and entering a building. That matter, Mr. Nossinger indicated, has resulted in a waiver of preliminary examination, so that will not be going. Also scheduled for today is People versus Sanford Dean Haley. File number is 252198FY. Mr. Haley is here present with his attorney, Rhonda Ives. Also present is Angelique Camfield from the prosecuting attorney's office. Let me actually click into the file. The allegation here is an assault with intent to do great bodily harm by strangulation, with 2 counts of domestic, 1 count of domestic violence and a count of interfering with a crime report. The felony charge is the assault with great bodily harm. That is set for preliminary examination today, and the complaining witness in that case is Crystal Lynn Allen. This allegedly occurred on June 16th of 2025. The complaint was filed with the court on October 23rd, 25. The defendant was arrested on November 2nd of 2025. Ms. Ives was appointed to represent the defendant. I saw him on November 3rd and he pled not guilty. Prelim was set for November 25th. Pre-exam was set for November 18th with prelim November 25th. The matter was adjourned. The court found cause to adjourn. I think they were unable to find a witness at that time. Prelim was set for December 16th. Nothing happened. The matter was continued again. And both parties asked for an adjournment on December 16th. And the matter was set for preliminary examination today. My understanding is today and each other day, Ms. Ives, defendant wishes to have a preliminary examination.
That's could be correct, Your Honor.
What you told me on December 16th is you have also been looking for the complaining witness to interview her, and you had an investigator looking for her, and you've been able to unable to locate her. Is that correct?
That is correct, and my investigator still is making almost daily attempts to try to reach her, find her. We had a working phone number for her that she had answered at one point, but I have not been able to have a conversation with her, nor has my investigator.
Ms. Camfield, what do you know from the people's perspective?
Thank you, Your Honor. The only information that I can provide is somewhat similar to Ms. Ives's. She appeared at my office at the last exam date with a letter purportedly authored. Ms. Ives,
oh, okay.
With her intern, I'm sorry. With a letter purportedly authored by Ms. Allen. I have no idea how it came into her possession. However, I had indicated to her, as I had indicated to the court that day, that unable to verify the author of that letter purporting to be Ms. Allen, I cannot make a motion to dismiss or make any offers in a case based upon something that's allegedly written by someone whose identity I cannot verify. I'm concerned about Ms. Allen's safety. I do note that purportedly the arrest of the defendant left her homeless when the no contact condition was put into place. And I do know that the Sheriff's Department, inclusive of Sergeant Penn, have been looking for her. Much like Ms. Ives's investigator, they've not been able to locate her. and she has not come physically into the office nor called me. I did call the number listed in the police report in an attempt to make contact with her to explain that I really needed her to come in and identify to me so that we could discuss the matter, and have not received any return calls since that time in December. And again, I called her today and have not received a return call. The people could potentially proceed with Sergeant Penn's statements of the victim regarding injuries that were seen on her person and photographic evidence, but are choosing not to go forward today based upon the fact that even though statutorily it may be enough for a probable cause bind over, it would become more difficult in front of a jury in circuit court to proceed due to confrontation issues. So we are unable to proceed today.
Ms. Ives, are you going to ask that the matter be dismissed?
Your Honor, yes, at this time I would make a motion that the matter be dismissed. Obviously, it could be without prejudice. So if this matter became an issue, the prosecutor could seek charges again, or if something, if they finally reach the victim and she does wish to go forward, that matter could be reissued. I certainly would advise my client to make himself available if that were to happen. But at this point, we would ask the court for a dismissal so we don't have to keep reappearing, and I could let my investigator off the case.
Mr. Haley, do you understand that a dismissal without prejudice means the case could be rebrought? The dismissal with prejudice means it's done. You can't recharge it. But no jeopardy is attached. No testimony has been taken. You haven't entered a plea. So if the matter is dismissed, it would be without prejudice and could be rebrought. Do you understand?
Yes, sir.
Well, this is a strange phenomenon. So this happened in June, and the parties then continued to live together from June to November. And then when he got arrested in November and no contact provision, she got forced out of the house.
That is my understanding, the best I can relay it to the court. And again, this information was provided in the letter whose author is unidentified, at least by verification purposes. It does purport to be Miss Allen, but again, I don't know her handwriting, I don't know her, and I cannot speak with her to verify that she authored that or the circumstances under which it was written.
Your Honor, might I add that the handwritten letter came to me in a photograph through a text message on my phone in my attempts to try to reach with her and schedule an appointment so my investigator could interview her. And that was the document I received. So I can't verify anything other than that is what I received purportedly from her.
I haven't seen it, but I don't need to see it.
Yeah, they were, the parties were living in his mother's home. So I think at that point, when the no contact order issued, she left the residence.
That's always a problem when there's a long delay between the incident and the warrant. There wasn't a big delay between the issuance of the warrants and the arrest, but it was 5 months later before he got arrested, and it often causes issues. All right, I've done an order granting the motion to dismiss without prejudice by the defendant. It's granted for the reasons stated on the record. Prosecution unable to serve complaining witness.
Thank you, Your Honor. If in fact I have any confirmation from Miss Allen herself about this process, I will certainly advise Ms. Ives. Thank you.
There was a $2,500 cash bond posted, I think. Yes, Mr. Haley, you're entitled to the return of your cash bond. You don't appear to have any unpaid fines or costs with the court, so you're entitled to the entire return of that bond.
Thank you, Judge.
Thank you. Good afternoon, Mr. Duchatellier.
Good afternoon, sir.
And that's how I've been saying your name, and people's names are important. How do you say it?
Duchatellier.
Duchatellier.
It's
All right.
it's French, so it's really pronounced Duchatellier.
Duchatellier. All right, I'll try my best. I took 3 years of high school French,
Okay.
and I can't even order off a menu.
I took it too, just so I could pass.
All right, you and I have been spending a lot of time together lately.
Yes, sir.
You're here with your lawyer, Luke Knopfinger, and I appreciate his willingness to take this case on. Mr. Knopfinger, may I see the waivers? I have two. Is there one on the assault case?
No, the assault we're dismissing right now.
Oh, all right. All right, there are two larceny cases, and you and I talked about these. File number 252138 alleges a larceny of building. Let me actually get into these. We're not under any time constraint, so we are able to take our time here. In that case, it's alleged that on October 14th, no, that's the wrong one. You were at the Walmart store and you stole a cell phone as a second habitual offender. And that was alleged to have occurred on October the 16th. And I have in front of me a waiver of preliminary examination that's been signed by Mr. Knopfinger and you, and we'll get Mr. Robert to sign it as well. It says, I, Mark David Duchatellier, say, I understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one, and I voluntarily waive my right to a preliminary examination and understand that I will be bound over to the circuit court on the charges in the complaint and warrant. And you've signed that. Is that what you wish to do, waive the preliminary examination in that case?
Yes, Your Honor. With the contingencies upon the plea offer.
Well, we're going to put the plea agreement on the record here in a minute. The next case is 251935. As I said, we're not under any time crunch here, so we can make sure we deal with this appropriately. In this case, the allegation is that on 8/8 of 25 in the city of Three Rivers, that you did steal something from Main Street Ladies, a store in downtown Three Rivers, by stealing cash. Again, as a larceny of building as a second habitual offender, which would be a 6-year maximum. Once again, I've seen the waiver and you wish to waive the preliminary examination in that case. All right, now.
Sure.
Mr. Knopfinger's been working on this case since he got involved in it. Mr. Aubert's had it from the start. So I understand, Mr. Aubert, there is a plea offer that is in the offing right now.
Yes, Your Honor.
All right, what are the terms of that?
So the plea offer is for the defendant who guilty to larceny in a building in each file. And we dismiss the R&O case as part of that plea agreement.
Larceny in a building without habitual?
Correct.
Okay. And the R&O case is the new case that he hasn't been arraigned on yet.
Correct.
What about the assault with a dangerous weapon case?
That's being dismissed today. No, we had victim issues on that case, so that's dismissed.
All right.
And we'd be making a recommendation for probation in circuit court.
So the charge of 239391, assault with a dangerous weapon. The complainant in that is Christy Keene, and there are currently some warrants for her arrest. I think she's actually been charged. And so will you do a nollie pros?
Yes, I've already asked our staff to do that.
Very good. And there is a new charge, 264 FY, that alleges that in Montville Township, you did resist, obstruct, oppose, or endanger Jason Van Dyken, a deputy with the Sheriff's Department. And that had to do with when you were arrested. And according to the affidavit, there was an incident where you ran a little bit, and then they had kind of a standoff where you had your hands on your coat. You're lucky you didn't get shot. Resisting and obstructing the police officer is a felony, punishable by up to 2 years in prison. As a second habitual offender, that makes it a 3-year offense. Are you gonna dismiss that case now, or do you want me to set it for something further?
I would ask the court to set it for a
Pre-exam conference? Mr. Knopfinger, will you take that case as well?
Why not, Judge? I intend to set it for plea as soon as possible. It takes some time for the case to percolate up to circuit court.
All right.
I guess I would be maybe urging for a dismissal at plea in these two cases to effect.
Yep. We would dismiss it when the innocent plea.
24264 FY. Point. Luke Knopfinger. All right, I appreciate that as well, Luke. It makes sense to keep it all with one lawyer. I'm going to set a pre-exam for Luke. Do you know what your duty week is?
It was this week. It was this morning.
No.
He has cases that were adjourned to next week.
All right, we'll set the pre-exam for
20.
113.
Well, my hope, Judge, in terms of judicial economy is that I can get him in front of Judge Stutzman as soon as possible. So I understand that he's entitled to a
All right,
preliminary.
well, I could set it for 120.
I think that would be better.
At 8:30. And pre-exam 120. 7:26 at 1. I'm gonna set bond at $2,500 cash or surety. Of all the standard conditions. personally appear for any examination, abide by any judgment entered by the court, do not leave the state of Michigan, do not commit any crime if you are released, provide telephone number and address upon release, do not use alcohol or any controlled substances. Do not use or possess a firearm. That ought to be sufficient. All right. Looks like this case is on the way to being resolved. I should also note, Pross will recommend probation circuit court. All right, you're gonna go back to the jail. Your lawyer's gonna make an effort to get this case set in circuit court. At one time, 100 years ago, after the preliminary examination, there would be a set arraignment date in circuit court. Everybody went to circuit court for an arraignment. About a week later, we took 70% of the pleas at that first arraignment date. Now, that's not a thing anymore. It takes longer to get the case up there and set for something, but I know you'll make your effort to make this move quickly. Mr. Duchatellier, you seem to be good today. I've enjoyed talking with you, and you've had some frustrations in your case, having it be reset and having to appoint a new lawyer.
Yes.
But the matters will be bound over to circuit court, and the one case is dismissed, and the other case apparently will be dismissed once the pleas are entered in circuit court. All right, you're good to go. Josh, let me fill these out and give them back to you, and then you can process them and send it back.
Judge, what was the bond that the court set on?
$2,500 cash or surety.
Okay, thank you.
Thank you. All right, let me get these straight. 138, the bond is $50,000 cash or surety.